When I traced where a lot of the confidence around bank-stored gold was coming from it was not from custody agreements, insolvency filings, or reserve law. It was coming from marketing copy. It was coming from glossy brochures and one-line summaries that made it sound like if your gold was at the bank, it was automatically safe, ring-fenced, and unquestionably yours. And that is exactly why I am making this video right now, because the legal reality underneath that confidence is a lot messier than most people understand, and somebody needs to explain it clearly. I am recording this right now from Chicago, and I want you to comment what day and date you are watching from, because this is one of those topics people ignore until the stress event is already underway, and I want the timeline to be crystal clear. And real quick, if you value this kind of protective, no-spin breakdown for regular investors, do me a favor, subscribe, and comment FinTalk OG so the algorithm knows you want more of this. Now here is the claim making the rounds. If your gold is in a bank vault, it is safe. If the bank fails, your gold is still your gold. End of story. And on the surface, that sounds obvious. It sounds like common sense. But when you slow it down piece by piece, you realize that it's clean, it is comforting, and it is also incomplete. Because the first place these stories usually get weak is when people use the word gold as if every gold arrangement is legally the same. It is not. Allocated gold is different from unallocated gold. Direct title is different from pooled exposure. Vault storage is different from a claim against an institution that stores on your behalf. Same asset, very different legal reality. So I am going to break down three things. First, what actually happens to gold claims when a bank gets into serious trouble. Second, the difference between allocated and unallocated in plain English, because this is where regular investors usually get trapped. And third, what you should actually do if you want gold exposure without learning this lesson the hard way. You are going to walk away calmer, sharper, and much more in control of what you own. So let us start with the core mechanism, because this is where the story lives. Here is the clean way to think about it. Gold sitting in a vault is not automatically the same thing as gold sitting on your legal balance sheet. That distinction matters more than the location. If you have specifically allocated bars held in custody with clear serial numbers, clear title, and clear segregation from the bank's balance sheet, that is one category of risk. If you have an unallocated claim where the institution owes you gold, but the gold is not specifically tagged to you, that is a completely different category. One is much closer to property. The other is much closer to a liability owed to you by an institution. And if that institution goes into insolvency, the difference between property and liability becomes the whole game. Let me be blunt. A lot of people think they own gold when what they actually own is an institutional promise connected to gold. That distinction feels theoretical in calm conditions. In a stress event, it becomes painfully practical. Here is what nobody wants to say clearly. When a bank is healthy, the marketing language around precious metals storage feels reassuring because nobody is testing the chain of ownership. When the bank is under stress, lawyers test everything. They do not care how the brochure sounded. They care what the documents say, what the custody arrangement is, who has title, and whether your claim sits inside or outside the insolvency estate. Now here is the skeptical alternative, and I want to give it fair weight. Could many bank gold storage arrangements still prove robust in a failure scenario? Sure. Some do have strong legal segregation, third-party custody, and clear title structures. I am going to say something that might annoy both sides here. Not every bank gold product is a trap. Not every custodian is sloppy. Not every institutional arrangement breaks under pressure. That is plausible here is how it can fail. Most clients do not know which structure they actually have. They assume safety because the brand name is familiar. They assume stored with us means segregated for you. And that assumption is where the risk lives. Stay with me on this because it matters. Think of it like airport tickets and seats. A lot of people believe that because they bought something called a seat, there is automatically a specific seat physically set aside with their name on it. In reality, some systems oversell, some systems allocate late, and some systems depend on operational assumptions holding together. If everything is normal, you board and you never think twice. If the system gets stressed, suddenly the distinction between a confirmed seat and a conditional claim becomes very real. Gold claims work the same way. In normal times, the structure is invisible. In stress times, structure is everything. Now let us talk about allocated versus unallocated, because this is where importance really lies. Allocated gold means specific bars or coins are identified and held on your behalf. You are not just owed an amount of gold, you have title to particular metal. Unallocated gold usually means you are a creditor with a claim to a quantity of gold, but not necessarily to specific bars. Here is what nobody wants to say. Unallocated is efficient for the institution. Allocated is safer for the client. Efficiency and safety are not always on the same side of the table. And if you want the uncomfortable truth, institutions often prefer structures that preserve flexibility for them, not certainty for you. That does not make them automatically dishonest. It means their incentives are not identical to yours. Your incentive is simple. You want clarity of title and access in stress. Their incentive is to manage liquidity, cost, and balance sheet flexibility. Those are not always compatible. Here is a question for you. If you own gold right now, do you know with certainty whether it is allocated, unallocated, pooled, or simply price exposure through an institution? Drop that in the comments because I think a lot of people would be shocked by how many holders cannot answer that cleanly. Now, before we get into the next part, I need to say one thing clearly. A bank failure does not automatically mean every gold customer loses everything. That is lazy fear talk. But it does mean you are suddenly in a world where legal structure matters more than emotion. Could your allocated gold survive intact? Yes. Could your unallocated claim become part of a broader creditor process? Also yes. Could access be frozen temporarily while legal questions get sorted out? Yes again. And if you are not prepared for that version, you will panic. This is where the plumbing of the system matters. The underlying technical dependency is not the metal itself. It is the chain of title, the custody agreement, the redemption language, and the jurisdiction. People focus on the vault door and ignore the paperwork. That is like staring at the faucet while ignoring the pipes in the wall. The flow only looks simple from the outside. So what does this actually mean for you? Here is what to watch. First, read the actual storage or account agreement and find the specific words allocated, segregated, title, and insolvency treatment. Second, check whether your gold is held directly by the institution or through a sub-custodian chain, because more layers mean more complexity in a stress event. Third, ask whether you have delivery rights, under what conditions, and whether those rights can be delayed or suspended. If you cannot get clean answers to those three things, you do not fully understand what you own. Tell me in the comments, are you holding physical metal directly, bank-stored allocated metal, or a paper claim connected to gold? And which one of those do you think is the real risk in a financial stress event? I read the comments, and that split tells me exactly where the confusion still sits. Now here is a simple action plan. No drama. Step 1. Write down every form of gold exposure you currently have and classify it honestly. Physical in possession, allocated storage, unallocated claim, ECF, mining stock, Futures exposure. Do not use fuzzy labels. Step 2. If you are using a bank or large institution for storage, request the actual custody documentation and read the insolvency treatment section. Step 3. Do not make the common mistake of assuming reputation equals legal protection. Chase documentation, not comfort. Step 4. If gold is part of your emergency insurance framework, keep at least some portion in a form that reduces institutional dependency. Do not just chase convenience, chase control instead. Now let us map two plausible paths without pretending we can predict the exact candle. Path 1 is the orderly failure path. In this world, a troubled institution goes through a controlled process. Allocated clients retain clear rights, access is delayed but ultimately preserved, and the legal distinction between property and creditor claim does the heavy lifting. If you are structured correctly, you survive the event with frustration, not devastation. Path 2 is the messy stress path. Access freezes, legal questions slow everything down, and people who thought they owned simple vault gold discover they actually owned a more complicated promise. Both worlds can be true in different institutions or different jurisdictions at the same time. That is not a crash call. That is a maturity call on the legal structure. Now here is the uncomfortable scenario. Forced liquidation and liquidity stress do not just hurt the weak bank. They hurt the customer who needs fast access and learns in real time that fast access was never guaranteed. That is why defensive strategy matters. Institutions protect themselves with documentation and process. You often protect yourself with assumption. An assumption is a terrible hedge. Here are the 4 rules. 1. Decide your maximum allocation first. Write it down. If you are losing sleep, you are too big. 2. When something runs hard and you are up a lot, take some off. Not all. Some. If your position doubles, consider trimming half. Lock in the original bet. Let the rest run. 3. Do not keep all of one thing in one place. If your gold exposure is entirely dependent on one institutional channel, that is concentration risk. 4. The best time to buy is not always when you are most excited. The best time to buy is when you can still breathe and structure it correctly. So here is what we covered. Gold at a bank is not one thing. Allocated and unallocated are not remotely the same. In a failure scenario, legal title matters more than marketing language. The real risk is not just loss. It is access, delay, and discovering too late that you owned a promise, not clean control. Stay thoughtful. Stay sized appropriately. Do not let the word gold trick you into thinking every gold arrangement protects you the same way. Now, here are my questions for you. Do you think most investors understand the difference between allocated and unallocated gold? And if a bank failure happened tomorrow, would you be confident that your gold exposure is structured the way you think it is? Drop your answer below and remember to include what day and date you are watching from. If you got value out of this, subscribe and comment FinTalk OG so I know you want to follow up on custody structures, vaulting, and bank metal exposure. And if this helped, share it with someone who says their gold is in the bank but has never once looked at the agreement. All right, take care of yourself, and I will talk to you soon. And just so we are crystal clear, this is educational content. It is my take based on publicly discussed information and my own reasoning, and it is not personal financial advice. I am not your advisor. I do not know your goals or your risk tolerance, and I could be wrong. Do your own homework. Consider your situation. And if you need personal advice, get it from a qualified professional who knows your situation.